in session. Please be seated.
Good afternoon. We're back for the afternoon docket of the July 16th Court of Criminal Appeals docket. As I said this morning, I'm Robert Montgomery. I'm from Sullivan County. To my right is Ross Dyer, who's from Shelby County, and Judge Jill Bartier is to my left, is from Montgomery County. Each of the sides will have 20 minutes. If you're the appellant and wish to reserve some time, just let us know on the front end. And oh yeah, and sorry about that. The officer's busy, so he didn't notice that the doors were open. Anyway, and the clerk will keep up with the timing, and the lights will go on. Let you know when your time is up. All right. Do we have any preliminary matters this afternoon?
No, Your Honor.
All right. Would you call then our first case this afternoon?
DeWayne Edward Harris versus State of Tennessee.
Mr. Harris, Your Honor.
Okay. You'll just approach the podium here. And when you're ready, you may proceed.
Your Honor, if I could, I'd like to reserve 5 minutes.
Certainly.
Thank you, Your Honor. May it please the court, on behalf of DeWayne Edward Harris, the appellant in this matter, would Your Honors like for me to first begin by regaling the court for a brief factual summary of this case?
However you want to proceed.
I'll try to be brief.
I mean, we have the briefs, but
yes,
at the same time, if there are things that you feel like you want to bring up, let us know about that. That's
absolutely
more than welcome to.
Absolutely. Owning in on the relevant facts of this case, Your Honor, this was a carjacking, aggravated robbery, and joyriding case out of Williamson County, in which the defendant, my client, got convicted of these charges. And interestingly enough, he had a co-defendant who actually got acquitted in that matter. And there's a lot of twists and turns in this case, but the main factual side of it I want to emphasize on is that he's accused of ripping the alleged victim out from her vehicle by her hair, punching her in the face, and hitting her again, and then just taking off in the vehicle. And so he went to trial, and prior to going to trial, his attorney and the state prosecutor, they made an agreement that certain evidence would be excluded. You see, Mr. Harris has somewhat of a background. He's been in gangs before, and so he's been referred to as Big What and Big Homie. Knowing that on the front end, trial counsel and counsel for the state, they agreed that, okay, that stuff would be kept out of evidence unless they had a jury out hearing, in which case they could address it with the judge.
Is that order actually in our record? I didn't look to see the order excluding that evidence.
I believe it is.
And I think what I gathered from the briefs is that they excluded reference that he was in a gang, but
yes,
it didn't specifically exclude the nickname, use of nicknames. Is that correct?
No, they didn't reference the nicknames, Your Honor, but I think I would infer that it's one and the same. I guess he could have done that, but I don't think it was necessary. It's when he's referring, detective's going to refer it over and over again as Big What and Big Homie. I think it's pretty clear what he's referring to. Perhaps the jury might not know one way or another, but that's the gang name.
Are you saying every time somebody has a nickname, it's got to be gang related?
No, I would not say that, but in the context of this case, words like Big What, Big Homie, that kind of opens the door for an inference elsewhere that doesn't involve the actual facts and inquiries of this case. And so I think what trial counsel should have done is, Your Honor, can we approach and judge, this is a gang name that the detective's referring to. We had an agreement. Let the trial court go from there. Instead, he did not do that.
Was there any other proof other than that? I mean, did any other witness testify about that they personally were a gang or that somebody else was in a gang? Was there any proof about gangs other than what you're talking about?
There was not.
So I go then back to Judge Ayers' question. If there's no proof anywhere at trial about any sort of gang affiliations or gangs being involved, me referencing somebody by their nickname, how does that mean that there's gang? How does that all of a sudden invoke gang affiliation?
Certainly. The problem here is twofold. First and foremost, we got trial counsel admitting at the post-conviction hearing that was in fact his gang name. I understand that.
But the
That
jury
was-
doesn't know that. Trial counsel can know that, but trial counsel can know that everybody involved in the case was a gang member.
Yes.
But if no one ever tells the jury that, that's what we're talking about. We're not
Right.
talking about necessarily what counsel knew, because that doesn't prejudice him at trial.
I think there would still be a need, though, because maybe some jurors don't necessarily think that's a nickname, and maybe some, being street savvy, they think, oh, hey, yeah, he's in a gang, I know that. I think an inquiry at very least should have been done, and truth be told, the trial counsel didn't have to leave this up to potential speculation. That's why he should have gotten up, made the objection accordingly, and addressed it with the court. And if we need to have additional voir dire of the jurors or something, we could have gotten to the bottom of that. But we don't know. We don't know one way or other whether or not the jurors necessarily knew those were gang names. But those were, in fact, gang names, and no inquiry was done one way or the other.
But no inquiry, but didn't trial counsel testify that he did object at one point, and then that he actually stopped objecting because he didn't want to just keep drawing attention to it?
He did testify to that. But here's the other problem, Your Honor, is that even though he should not draw attention to it, when it gets to the point when it's brought up over and over again, he has a separate remedy, which is to go before the court, jury out, ask for a mistrial, so that the court can deliberate over whether or not there's such manifest prejudice that this case simply needs to push aside, restart, and we'll go forward in a way that this stuff can't be brought up over and over and over again. And that's my key contention here. I know we bring up stuff about trial counsel having medical issues and failing to secure a private investigator, failing to secure medical records and whatnot. I could get into that over and over again, but based on y'all's prior opinions, I've been defeated enough times to know that y'all can just come back and say, well, that's just trial strategy, or the evidence so overwhelming it would not have mattered. I don't think that position, however, gets us past the fact that this guy should have asked for a mistrial in order to preserve Mr. Harris's right to a fair trial in the first place. And so I guess, based on your comments here, the issue here is, as far as you are concerned, is the jury, did they not know about that necessarily? And so in light of them not necessarily knowing that there was these gang-affiliated names, was Mr. Harris, in fact, prejudiced?
Right.
And my position is that this court should err on the side of caution, and that we know those names were, in fact, gang names by what the trial counsel is stating. And we don't know one way or another what those jurors thought. But nevertheless, the state violated its agreement. And so I would hold that the court should hold that the trial counsel should have asked for mistrial. And as we've seen the transcript over and over and over again, he regretted it greatly. He admitted it. He said he should have done this. He should have asked for mistrial. He doesn't know why he did not. If that's not indication of ineffective assistance to counsel, I don't know what is. And being that that's my key contention, I think that's where I'll reserve my time, and I guess I'll go for rebuttal depending on what they say. Thank you very much.
Thank you. General?
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the denial of post-conviction relief because the petitioner cannot establish that trial counsel's performance was deficient or that he suffered any resulting prejudice therefrom. So petitioner sort of raises three different bases for why he feels that counsel was ineffective. And I think we're taking them sort of in reverse order from how they were briefed. But the first one, and the one that he has primarily presented to this court today, was that counsel should have objected to the use of these nicknames at trial. And I think both Judge Ayers and Judge Dyer, you sort of hit the nail on the head. First, this doesn't really even rise to the level of what was agreed to be excluded. This doesn't rise to the level of gang activity or gang membership or anything of that nature. So it simply, there wasn't anything to object to. But going beyond that, if we look at the prejudice, or at the Strickland prongs, first, counsel wasn't deficient here because first he did object initially, And then he testified at the post-conviction hearing that he made the strategic decision not to object anymore, to call attention to it,
Would it
because
change the case if the defendant's nickname was Shooter or Killer?
I don't think it would change this case at all. I think it might make it a closer call as to whether that qualifies as gang involvement and whether that even fell within the pretrial agreement. But when we're looking at it under the lens of ineffective assistance of counsel, it wouldn't. Because again, trial counsel's testimony is, I didn't want to raise attention and raise the jury's awareness to it. Because to the extent that the jury, didn't know that it was gang involved or gang related initially, if counsel repeatedly objects to this over and over again, that could get the jury to hone in on it and think that there might be something up with it. But even if this court thinks that counsel should have objected and that his strategic decision not to wasn't objectively reasonable, which the state submits it was, the petitioner still can't establish prejudice. And I think something that was said earlier today is important. The petitioner today said, we don't know whether the jury knew they were gang names. And I think that is fatal to his claim of ineffective assistance of counsel. On post-conviction, the petitioner bears the burden of proving both prongs of Strickland. If he can't establish that the jury not only knew that these nicknames were gang-related, but that the fact that they were gang-related somehow affected the jury's determination of guilt, he can't meet his burden of establishing prejudice. So for that reason, we submit that counsel was effective for choosing not to continuously object to these nicknames. I will very briefly go over the other two bases of ineffective assistance of counsel. I think they were briefed, but just to hit on the high points. First, these alleged medical records. He believes the petitioner claims that counsel was ineffective for failing to obtain medical records. I do want to point out we have a single medical record, if it could be called that, in the record on appeal. So to the extent there are some other medical records out there, doctor's notes, things like that, the petitioner has waived those by failing to present them under black. But the one note we do have is a doctor's note that says the petitioner tripped and fell and hurt his thumb. And I think that can most easily be dispensed with the prejudice prong. That would not have in any way prevented him from dragging this victim out of her car or from punching her, and so it would not have had any impact on the jury. Petitioner can't establish ineffective assistance. And lastly, this pretrial investigation, part of that is the medical records. I think we've covered that. Part of it is that the petitioner feels that counsel should have gone and obtained some surveillance video. We have testimony from counsel that a co-defendant's attorney had gone and looked for it and that there wasn't any there. So we don't have deficiency for not going and investigating something you think is not there. And the petitioner also failed to present that at his hearing, at the post-conviction hearing. So again, under black, that issue, he cannot establish prejudice. If this court has any other questions, if it doesn't have any questions, we ask that this court affirm the denial of post-conviction relief. Thank you.
Briefly, Your Honors.
Certainly.
I think, just to touch basically on Strickland, I think deficiency is proven simply by trial counsel admitting it at the hearing. And if you could read some of the comments that the court is even making, it looked like the court was initially going to come down the other way. Maybe perhaps they're reaching a different conclusion about whether or not gang names meant one thing, whether or not those names were actually gang names or not. But I don't think deficiency is really in dispute because he confesses to it. That's in there multiple times. I think the issue is prejudice along the lines of what you all discussed, which is that how do we know they knew it was gang names? And I think in writing your opinion, at very least, it should be a factor of addressing, perhaps future cases, what trial counsel should do in a situation like this. I mean, he can't just ask about it at voir dire or something without exposing that to the jury or one way or another. I think it puts too much of a burden on the defendant, and that we should just presume, based on his admission of saying those are gang names, that that's enough to establish prejudice. Nonetheless, that's my position, Your Honor, and I thank you for your time.
Thank you.
All right. Madam Clerk, would you call the next case, please?
State of Tennessee versus Tashawn K. Patterson.